Evening, everybody. Herewith, I call the zoning board, the Highland Park Zoning Board meeting to order at 7:34, 7:33. And okay, we're supposed to do now. We're supposed to do the pledge to allegiance.
Everybody could stand for the pledge of allegiance.
United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Meetings will be live streamed via Zoom. Public comments will be allowed for general board matters, excluding applications for development. Members of the public who wish to ask questions, present testimony, or present witness in applications for development must be present and in person at the location indicated. To view or listen to the meeting electronically, please follow these instructions. So, the meeting was called to order.
Not yet. What we need to do is to swear in a number of members. And those of you that are going to be sworn in, if you would please stand. And all of us. Yeah, exactly. If you'll raise your right hand and repeat after me, everybody. Not everybody. No, you're good. You're good. Okay. Repeat after me. I, and then state your names.
I, Wolfram Hofer,
You solemnly swear or affirm
solemnly swear or affirm
that I will support the Constitution of the United States
I will support
the Constitution of the United States
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance to the same
and true faith and allegiance to the same,
and to the governments established in the United States
and the government established in the United States
and in this state
and in this state
under the authority of the people,
under the authority of the people,
and that I will faithfully,
and I will faithfully,
impartially,
impartially,
and justly perform
and justly
all
perform
of the duties
all the duties
of the office
of the
of the
office
zoning board member
of zoning board member
according to the best of my ability.
according to the best of my ability.
So help me God.
So help me God.
Now, what I'm going to do is pass out, if you would, I've already acknowledged them, but if you all sign and then pass them over to Maureen, please. Now you can sit down.
So, the meeting was called to order in accordance with the Open Public Meetings Act. Notice of this meeting was provided to the Home News Tribune, the Star Ledger, and the Highland Park Planet on February 3rd, 2025, and was posted on the Borough website at www.hpborough.com and on the bulletin board at Borough Hall in 222 South Fifth Avenue, Highland Park, New Jersey, and has remained continuously posted as required by law. Fire exits are to the left and to the right of council chambers. And please speak into the microphone. And just a note, actually, like a personal note for the applicants, we are not all new. Just change positions. Like I've been on this board for 20 years and just now became the chair. So welcome to Highland Park and we can proceed. So actually now you call the roll, right?
Yes.
Mr. Fletcher,
Present.
Mr. Dickinson, Mr. Pheasant,
Here.
Mr. Hofer,
Here.
Mr. Holzapfel, Ms. Corbin. Here. Ms. Leslie. Here. Mr. Rothberg,
Present.
Mr. Vining,
Present.
Mr. Walsh,
Yes.
Mr. Winfrey.
Ms. Walsh.
Miss
Oh,
Walsh.
they have Mr. I'm so sorry.
Present.
Mr. Winfrey, Mr. Thomas,
Present.
Chris Crescenzo,
Here.
Mr. Bruce Crotch,
Here.
and Councilmember Hale.
So our first agenda item is a hearing of new cases.
There is also the way the agenda is set up is that there is comments from the public, but not related
Oh,
to
yeah.
any application that's on the agenda. If there are any comments, now would be the, if there's any comments, now would be the time.
Anything that is not related to.
Correct.
to-
And seeing none, we can close that. Thank you.
Now we get to hearing of new cases. which is the applicant is GSH Incorporated. And the location is 2220 South 4th Avenue, block 2901, lots 29 and 30. And the docket number Z24-01. And it's a request for minor subdivisions C and D variances and request for waiver of submission requirements.
Council, when you're ready, you can identify yourself, please.
Yes, sir. Sandy Galatio, Windells, Marks, Lane, and Mittendorf here representing the applicant GSH Inc.
Thank you.
Chris, I think that there has been a number of discussions with regards to the issue of complete. Recommended the application be deemed complete. Am I correct about that?
Yes,
I'm not going to go through the various reports, but I think the last report has indicated that that's your position, correct?
the second last report dated June 17, 2025, section 2, given the scope of the project and reasons provided by the applicant as part of the application submission, I recommend that the board grant the requested waivers.
Okay. Is there any questions of yes, so if not, Mr. Chairman, I would request that we solicit a motion to deem the application complete, granting the waivers requested.
So I place a motion to deem the application complete. Who's second? I will. The roll call?
Is there a second?
Yeah.
Okay.
Mr. Becker? Mr. Hopper?
Yes.
Mr. Halsapple? Ms. Corbin? Ms. Leslie? You abstain. Mr. Rothberg?
I'll abstain as well.
Mr. Vining?
Yes.
Ms. Walsh?
Yes.
So
Yes.
Yes.
Is that everybody?
we got everybody?
Yeah. I'm a yes.
Okay, I got you.
Good. Excellent. Very good. All right.
Council, if you want to make an opening statement, feel free, or your witness, whichever you prefer.
Thank you. I'll just make a brief opening statement. We have provided notice of this hearing pursuant to the municipal land use law and submitted an affidavit of service of notice to the board. The applicant GSH Inc., also known as Garden State Home, provides low-cost housing and support services. Applicant is the owner of the subject property at 220 South 4th Avenue, designated as block 2901, lots 29 and 30, which is located in the RA single-family zoning district of the borough. Contains an existing dwelling with 3 affordable units. Under the bulk standards that apply to the RA district, the 2 existing lots are undersized with respect to minimum lot area. Because they are under common ownership, the lots are considered to be merged under the law. Accordingly, the applicant is proposing to subdivide the subject property in order to create a new lot and construct a new 2-family home there with 2 affordable units. The new dwelling will be occupied by low-income veterans. I have 3 witnesses tonight. I'm going to call my first witness, Michael Goldstein, our civil engineer.
Unfortunately, it looks like we only have the one microphone, so we're gonna have to share it.
We'll go back and forth.
That'll be fine. All right, sir, do you swear or affirm the testimony that you're about to give will be the truth, so help you God?
I do.
Would you be kind to state your name, spell your last name, and give us the location of your offices, please?
Michael Goldstein, Goldstein. I'm employed at Van Cleef Engineering. My office is at 1705 Route 37 East in Toms River.
Thank you very much.
Okay, Mr. Goldstein, you're licensed as a professional engineer by the state of New Jersey, and your license is currently in good standing?
It is.
So we welcome you having a witness in front of you.
Thank you.
Here, and your firm prepared the survey, plot plan, subdivision plan for the application being heard tonight?
I have.
Oh, good. Thank you very much, Mr.
Isn't that extra microphone good? And you have prepared testimony for the board concerning the application.
I have.
Can you provide that testimony, please?
I will.
I see you have a number of exhibits. Are those exhibits just blow-ups of what was submitted, or are they modified?
So I have 3 exhibits that are the plans that are part of your application package, and I have 1
That is not.
that is not.
So we'll mark the one that is not right now. That is A1. It looks like it is a rendered aerial, presumably of the site.
That's correct. Aerial view prepared by me, Michael Goldstein, dated September 29, 2025.
Very good, thank you. That'll be A1.
So the site in question is known as 220 South 4th Avenue, Highland Park, block 2901, lots 29 and 30. The site is located between Harper Place and Benner Street. The existing site contains a 2.5-story, 3-unit dwelling, and it also contains a detached garage in the rear of the site. Driveway is presently provided on the north side of the site between these 2 existing buildings that leads to the detached garage in the back of the site. This is just a 24 by 36 version of the plot plan that is last revised 8/5/25.
And that was already submitted as part of the plans, right?
Yes.
All right.
So the southerly portion of the property is presently vacant, and we are proposing a duplex in this portion of the site. As our council previously noted, the site contains 2 lots, lot 29, lot 30. But under the merger doctrine, they've been consolidated for tax purposes. We're proposing a subdivision to create a new property line. It's not in the exact location of the existing common property line between lots 29 and 30. It's a different property line, and that's mainly to help with the fireproofing standard between the side of your building and the property line. We ultimately defer to tax assessor for designation of lot numbers, but to avoid confusion with existing lots 29, 30, it's recommended that they rename the lots 2901 and 3001, but ultimately we defer to the tax assessor on how they want to assign the new lots. So the footprint of our proposed structure is 65 feet by 18 feet. There's a porch on the east side of the site, and there's a walkway connecting from the porch into the driveway. We have our driveway on the opposite side of the site on the southerly property line. So we're proposing a new driveway entrance, a 10-foot driveway, and that'll.
Excuse me, I just have to note that Mr. Holzapfel has arrived at 7:45. Sorry.
So we have a 10-foot driveway leading to the rear of the site. We're proposing to provide 2 angled parking spots in the rear of the site. Yeah, let me
Turn a little bit.
We're proposing 2 angled parking spaces in the rear of the site. Concerning roof runoff, we're proposing a dry well that's also going to be located in the rear of the site. We performed test pits. We found that there was adequate soil conditions in order to infiltrate roof runoff. So generally, the roof runoff is going to enter into the dry well, and runoff from the driveway is going to either run to the rear of the site or to the front of the site, pretty much mimicking existing drainage conditions. The site is requesting relief for the number of required parking spaces under RSIS, but we are proposing to provide 1 parking space per unit. Additionally, and per the board planner's recommendation, the existing detached garage on lot 30, lot 3001, the existing lot with the 3-unit dwelling is proposed to be demolished. And we're proposing to provide parking in the rear of the site where the detached garage was. So we're proposing 3 new parking spaces on existing lot 30. Presently, we have the parking lot set 2.4 feet off that rear property line. Per the board planner's recommendation, we have no objection to moving it to 3 feet. Ultimately, we just shift the parking about 0.6 feet, about half a foot closer to the house. We do have bollards proposed between the house and that parking area to protect the house, to make sure that any backing out cars aren't going to hit the house. The bollards are placed 5 feet on center. The Bilco door that's also in the rear yard is to be removed so that it can accommodate that new driving area. With respect to water and sewer, public water and public sewer is available on the street. On my plan right here, we have our water connection and our sewer connection. Road opening was brought up in the board engineer's review letter. We actually have no objection to paving between the furthest extents of the trenches and all the way to the center line of the road. So instead of just trenching out the 3 feet on either side of the utility, we'll go to the center line of the road to the furthest extent. So it's one clean patch, not too salty, just in an effort to beautify the area. We're also proposing the concrete apron and the concrete sidewalk, and any concrete that's damaged during construction is going to be removed and replaced to make sure that this is a good looking site at the end of construction. We have no objection to those being conditions of approval if the board acts favorably. We also, per the board planner's recommendation, included what I think is a pretty comprehensive landscaping plan. We have a combination of shade trees, evergreen trees, and low-lying shrubs in the front yard. We have sugar maples, white oaks, Carolina silver bells. And then in addition, now that driveway on existing lot 30 is going to have a 3-foot buffer. So I'm talking about the northwest side of the site. We have no objection to proposing evergreens between that parking area and the rear property line to prevent any headlights that are driving in that driveway from shining into the neighbor's backyard.
Can I just clarify one thing? My plan seemed to suggest that the lot on your plan that is on the top, is that lot 29? Are you referring to lot 30, or am I just mistaken?
I may have misspoke before. Lot 29 is the northerly lot. Lot 30 is the southerly lot.
I just wanted to clarify that.
And 30 is the currently empty, what you consider empty lot.
Correct.
Right. Thank you.
So with respect to sewer service, per New Jersey Administrative Code 714-23, each 3-bedroom dwelling unit has a projected flow of 300 gallons per day. So a total of 600 gallons per day is the projected increase into the sewer on Highland Park. I don't expect that to be a capacity issue, but any approval will be contingent on receiving final approval from the borough water sewer authority. So there was also comments concerning the driveway apron servicing the existing northerly house. The existing driveway is narrow. That's an existing condition that we're not proposing to modify. It's 7.5 feet. Ideally, it should be 10 feet like the driveway that we're proposing here. As far as the driveway apron goes, even though the driveway is undersized, the apron is what a typical length apron would be. And I would request that condition stays the same, and we're not modifying the driveway apron to match the driveway, just so that even though vehicles are turning into a narrow driveway, they have the extra vehicle turn path to be able to maneuver themselves in and straighten it out. As far as the concrete sidewalk between the landing of the existing house and the sidewalk, we're happy to comply with any recommendations that the board planner has. I would encourage the board to have it remain as concrete, just because everything is concrete out there. But if there's an area that pavers would be appropriate, we have no objection to complying with those recommendations from the board. With that said, this is a duplex containing 2 units on the existing vacant lot. From an engineering perspective, it functions very similar to a single family home. I don't think that there's gonna be adverse impacts with respect to drainage. And I think the front of it is gonna look frankly better than it does now, just with all the new landscaping that we're putting in. I think it's gonna be a very big improvement to the area.
Complete your testimony?
I have.
Wolfram, can I ask you a question?
Yeah.
My sister owns a property on Harvard Place, which is perhaps 100 yards from this property. Am I still eligible to review this?
Well, but your sister is not within the 200-foot.
She is.
She is. So in other words, she received notice,
She did.
and I have to ask these questions, and I apologize, but it is necessary. You have a relationship with your sister,
I do.
and do you end up in provide her with advice with regard to her property and matters involving her finances, et cetera?
I do.
I would request therefore that you step down.
Thank you.
Now,
Sorry.
is there anybody else that ends up having a conflict?
Is now the time to ask a question about this presentation, or do we wait? till the
In
end?
just a second, let's let the board members ask some questions.
Okay.
There will be an opportunity to ask questions of this witness by members of the public immediately after the board finishes.
Okay, thank you.
Thank you.
Before you continue, could you just tell us who the additional witnesses will be so we can determine if we want to ask questions now? Or
We will have to complete that application presentation first.
we just want to know
Well,
who the additional, who might be giving additional testimony.
I'm sure well, the answer is yes. Council, do you mind providing? If you don't want to do the names, you're gonna have the names eventually. What the disciplines are involved?
I do not mind giving the names. We have Louis DeLucia, principal of the applicant, and Nicholas Graviano, who's our planner, to provide the planning testimony.
There you go. Okay. Unless there's any other questions.
Okay, so you would continue your testimony.
Nope, he has no other testimony.
You not, but then the next one. Oh, do we have a special question for
No, I
this?
think we need to open it up to
Okay.
the public at this point in time. And again, right now, this is only for questions of this witness. If you have comments or concerns, either positive or negative, they will be held at the completion of the applicant's testimony, which will include not only this witness, but also the other two witnesses. And with that, young lady, if you have questions, no, this young lady, but we need to get you up here so we get you on the mic.
Please take
And
one of
if
those.
you- yeah, if you take that, I don't care which mic you
All
take.
right,
If you don't mind, if you mind stating.
where
your
do I
name,
stand? Here?
Wherever you'd like.
Is this
But you
okay?
need to state your name and your address and spell your last name, please.
Okay, my name is Lisa Huber. Last name E as in boy, E-R. My address is 218 South Fourth Avenue on the first floor. I'm a tenant in it's a two-family building. The landlord lives upstairs.
Oh, you didn't have to give us all that, but anyway,
Okay.
so you have
But
a
that's
question.
who I
just
am, and
now.
that's why I'm here. So my question to you is, I heard you mentioning bushes or things that could help mitigate what would now be traffic coming down this driveway that really, as a resident who's lived there for 4 years, is really not a thing right now. And you mentioned bushes, but on the 218 side, there's like literally nothing. It's like we have next to 218, a strip about this wide on our property, and then immediately is the driveway next to that. And then we have our backyard, and like my
Well,
bedroom
before
is
you get
right
into
out
those,
back, so I want to understand where the bushes would be that you
I
mentioned
think
in
the
your
question is,
presentation.
can you explain in further detail
Yeah,
what the, and I'll use the term landscaping proposal that you have that may mitigate, and I think you said traffic, but I suspect what you're really talking about is the lights from the cars that are coming from the main road to the back of the property.
yeah, lights or noises of vehicles and things like that. So that's my question.
If you wouldn't mind, my plan is right here. Which property is 218? Is that to the south or to the north?
Um,
If you're looking at the house from the street to the right,
To the right.
so
So it would be to the north.
to the north.
Yeah,
Okay,
show
got
me where the building is. On the picture.
You're 218, right?
For the members of the public, move to the side.
Ma'am, if you don't mind, you can have a, you want to
Yeah,
just sit
sure.
down, please?
Well, I can't.
Well, I understand, but right now you'll have an opportunity to
I
ask
will, thank
questions
you.
and make comments later, and maybe even next.
So it sounds like if you're standing on South Fourth Avenue, looking at our house, it's to the right of our house, which would be page up or north on my plan. So predominantly, there's not really any changes to what the existing conditions are compared to what we're proposing. The main difference on this lot is that we're demolishing that detached garage in the rear of the site and just paving it so that we get 3 parking
So
spaces.
this is the garage?
This is the, if you can see
So
garage,
then this is our building.
yes.
Okay, so there is nothing to mitigate lights and noise and stuff to our building because we're here.
So there's an existing driveway there now,
Yes,
and the driveway is proposed to remain.
yes.
The only difference between what's there now and what's proposed is that this detached garage is going to remain. The landscape I'm referring to is mainly in front of both of the existing building and the proposed building. We're not proposing any landscaping on the northerly property line.
Okay. Great, thank you.
Thank you, ma'am. Any other questions? Yes, ma'am, if you'll take that mic, state your name, spell your last name and your address, please.
My name is Carla Yanni, last name Yanni. I live at 334 Summit Place.
Okay, go ahead.
Okay, so I have a couple of questions, and if I'm asking a question that's outside the scope of this,
Well, somebody will tell you.
somebody will tell me. Okay, so the first, could you put up the aerial view, please? The
Well,
first show, because it's relevant to this. So
Okay.
to talk about the rear of the lot and to say that the water runoff will run toward the rear of the lot, I think we need to point out here, this is not a
Hold on.
typical scenario
Miss-
between a lot.
Hold on. As I said to you earlier, and to all the members of the public, this is an opportunity to
I'm
ask
asking
questions.
him a question.
I haven't heard a question yet.
Okay, I'm ready. When you say it runs to the back of the lot, I want you to be aware that the back, this is not a typical arrangement where one backyard leads to another
So the
backyard.
question is,
This backyard leads to
What is
my
the question?
kitchen
the
and my
question,
backyard. So when you talk about headlights, they're going into my kitchen. So it's not a typical scenario when you say back of the lot.
Ma'am,
the
So tell
question,
me more
ma'am,
about the
ma'am,
runoff to the
what
back of
is
the
the
lot.
question?
Tell me more, could you please tell me more about the runoff at the back of the lot, which immediately runs into my backyard and my basement? That's the part that I'm unclear about. Can you tell us more about the engineering? You've asked for, among the 29 variances, one of them is maximum impervious coverage by the town is 40%. You're asking for 73.99%. That's a very big increase.
So the question is, what is the effort that you have made with regard to the question of drainage, which is what I think the questioner is fundamentally asking?
So I think that the plot plan would be a helpful exhibit. So I understand that existing drainage conditions, a portion of the lot drains to the front of the property, it drains to South Fourth Avenue, and a portion of it drains to the rear of the property. So what we propose to avoid adverse impacts to our surrounding areas and to maintain existing drainage patterns is to propose a subsurface infiltration basin or a dry well that's going to be sized to capture and infiltrate the runoff from the roof. We provided soil testing to show that subsurface infiltration basin should work as designed and intended. The portion of the lot that's flowing into your backyard is, there's a break point on the driveway where a portion of it, and that break line matches what the existing break line is of the property right now. So the driveway drains to the front of the street, and the remaining portion of it drains overland to the rear of the property. We do have a grass area between the edge of the pavement and the common property line in question. And to preempt any concerns, I don't think that our client would have any objection to proposing additional landscaping in that back portion of the site to mitigate any type of headlights that are coming from the new driveway that's being proposed. And I think that grass area is going to capture, receive, and generally infiltrate a lot of the stormwater that is being created of the new impervious surface.
You have another question?
Yes, I do.
A question? And if
Yes,
you don't
I have a
mind, if you
question.
don't mind, you need to take the mic.
No problem. So so the new construction, the house, the two unit construction and the driveway will cover 70% of the land. How much of that is it all impervious? I mean, it's not at all is it comparative to the current amount of runoff if you're gonna cover almost the entire plot with building and driveway?
Thank you for that question.
So the existing lot doesn't have impervious coverage. The roof area and the pavement is considered fully impervious
So the
surface.
grass.
The grass would be the portion of the property that isn't contained by the building or the driveway.
I think that there was a question about lot 30
Yeah.
and what's going to be done. Well, I think the essence of the question is, are you mitigating the entirety of the extra runoff that's going to be occurring as a result of the structures that are going to be on lot 30? And if so, is that going to be done by the dry wells, or is there something else that needs to be done?
So the dry well has been submitted and reviewed, and I'm happy to work with the board engineer to satisfy any further concerns. As far as the driveway goes, a portion of it flows to the street, a portion of it flows to the back. If there's additional drainage measures in the rear of the property that we can propose, whether it's another yard inlet with some perforated pipe to capture any runoff in the driveway, I don't think you'd have any objections proposing that to reduce any impact to the rear of the site.
Is there enough room in the rear of the site on lot 30 to be able to do additional mitigation?
I think that we could propose an additional system in this area. I would just request that we don't need to provide any additional soil borings. We have 2 soil test pits, in the immediate vicinity. I have no objection to doing, another.
And just so that the record's clear, you're talking about on lot 30, I guess what would be called the northerly portion of lot 30, near the rear of the property.
That's correct.
Okay. Any other questions, ma'am?
Oh, yes.
Want to get the mic?
Yes.
Why don't you keep the mic until you're
Okay.
done?
Just a point of clarification. You mentioned the bollards were those at the side of the driveway or to the back of the driveway? And then you mentioned 3 feet from the rear of the lot. That was an increase from 2.4. Excellent. Okay. So my question is there enough space if you are able to do additional landscaping to prevent adverse impacts on the immediately adjacent land? So my land is exactly adjacent to this. It happens to be on Summit Place, but it abuts both of these properties. Is there enough space? 3 feet doesn't seem like enough space to do the kind of landscape screening that I would hope for. Oh, no, I'm done.
Just one quick question, ma'am.
Yes.
Is your lot behind these lots? Is that what you're saying?
Yes, my lot
Just wanna be
is
certain.
right here.
Gotcha.
There's no road in between.
Got it.
It completely abuts both of these.
Understood. Thank you very much.
There was one more question in the audience?
No. I don't think he's answered this question.
Okay.
So
Landscaping.
we previously had the parking lot designed to be 2.4 feet off of that rear common property line. We increased it to 3 feet in order to provide landscaping. What I would generally recommend is that if we're planting, green giant arborvitaes, evergreen trees that are gonna be 6 to 8 feet tall at mature height, and they're gonna be green all year round. not just during certain seasons, that we space them at 1.5 feet off center. And this is my personal opinion, I prefer when the trees are staggered. I don't like when they're in a perfectly straight line. I prefer to have them off center from each other. So yes, I do think that if we're spacing the trees staggered 1.5 feet on center, that it will adequately buffer, headlights from a residential neighborhood going into that property. Additionally, I don't think we would have any objection to proposing 6-foot fencing along the rear property line if that was something desirable for this resident.
Any other questions? I would ask that you not participate.
Excuse me?
No, Mr. Pulsar.
No, I understand you have a question, but you are also a board member. And therefore,
But I'm not participating.
but it is my opinion that when you end up stepping down, you are stepping down and therefore you should not be participating in the matter. If you want somebody else to ask a question on your behalf, that's fine, but I would ask that you not participate. Thank you. Is there any other, yes, sir?
I'll ask you a question for you.
Yeah, you need to get the mic and then identify yourself by stating your name.
I would like to know if they've done a percolation test. And if
Just
they've considered
more
buying
quietly,
this as a city
in the back.
schools.
Jim Polos, 48 Skyview Terrace in Highland Park.
Could you spell your last name, Mr. Paulos?
Sure, P as in Peter, Olos. So just a couple of general questions for you. I assume that,
Oh, can you repeat the address, please? We didn't get it.
I'm sorry?
We did not get the address.
Oh, I'm sorry, 48 Skyview Terrace in Highland Park. I assume in your experience, you build a lot of homes and do the engineering design for them.
City storm sewer.
Okay, I'm sorry.
No, we can, you can take,
Oh,
I'll take.
share the mic. Thank you.
I prepared the site plans for many single-family homes and duplexes.
Could you reiterate what the width of the driveway is? I believe you said it was 7.5 feet.
The existing driveway as it currently today is 7.5 feet on the northerly lot 29, and that's proposed to remain
And the driveway that you're proposing is how wide?
10 feet.
And why is it 10, why is 10 foot selected?
So 10 feet is a typical width of a driveway. Just for comparison, a parking space per residential site improvement standards is 9 by 18. So 10 feet is so that you have a little extra room on either side of the car while you're driving. A typical highway lane that you would see on the freeway is 12 feet. So 10 feet is typical for a driveway.
And would 10 feet be a sufficient space for the two cars that are pulling in and having to park on the diagonal to be able to safely back out?
So it's it is not a desirable situation for cars to back out onto South Fourth Avenue, but that is a very common element of vehicles in this neighborhood. If you look at most of the streets and most of the houses in the neighborhood, they do have to back out into South Fourth Avenue just due to the width of the driveways.
Understood. And you believe that 10 foot that you've designed will provide sufficient safety for those people to be able to properly back out?
I do.
That's good. In that light, what is the safety factor for someone who's trying to back out of a driveway that's 25% narrower than the 10 foot you recommend?
So this driveway, I think you're referring to lot 29.
That's correct. You indicated it's a 7.5 foot driveway, and you were proposing 3 additional spaces in the back, which obviously signals a rather heavy use. It's actually 33% more than you're proposing with the 10 foot wide driveway. So my question to you is what's the safety factor for the 3 individuals parking in the back, backing down a 7.5 foot, 50 foot long driveway?
So originally, there was a detached garage there, and it wasn't necessarily used for parking, but it had the ability to provide parking. So I don't think that we're necessarily adding or intensifying the use. The use is a 3-unit dwelling that's proposed to remain 3 units. And when we removed this driveway, we actually added a key slot right here. That's what I call it. And this is a 24-foot aisle which is a typical width that you would see in a commercial plaza. So these cars actually have the ability to back out and perform a K-turn to pull out forward on the narrower driveway.
And you indicated that bollards are being installed, is that correct? And the purpose of the bollards is to protect what?
The house. So we have the driveway, we have the 9x18 spaces, and then we have a 24-foot drive aisle. And then we have 3 bollards proposed along the back of the house between the driveway and the house to make sure that no one backs into it by accident.
So would you say that the intensity of the use is one of the reasons why you're requiring bollards to be installed?
No, I don't think that the intensity of the use is changing. It's a 3-unit building now, and we're proposing to keep it a 3-unit building. And frankly, the reason that we're proposing the 3 spaces in lieu of the detached garage is from the recommendation of the planner to provide sufficient off-street parking for the tenants of that use.
In other homes that you indicated you have experience in designing, do you normally put bollards on the property to protect the home from someone driving up their driveway?
Depends on the situation.
Is that customary is my question.
It was appropriate in this case.
That's specific. I'm asking in the general sense as a designer and engineer. Do you normally, my question is would you normally install bollards in the design for a single family home or a duplex in a normal situation? Is that customary?
Where
That's a general
appropriate.
question.
Yes, where appropriate.
Okay, you want to answer the question. It's okay. I understand. That's not the question. The question is it customary? I think you're professional. You should give a professional opinion. Is it customary to do that?
I think it's appropriate, you know, in a typical house, you may have a driveway pulling into a garage where you can't have bollards protecting the driveway from the house. But yes, I would say it's customary to protect structures from drive aisles.
I understand why bollards are installed, but the question, and it's okay, you don't have to answer the question. The question simply was to the board, just to note that it's not being answered, is our bollards normally installed in a typical residential setting for the design of a home? I think the answer is no, but I'm not the professionals you are, so we'll leave that where it is for the moment. Could you tell me the distance, please, between the outermost portion of the existing house on 29 and what the distance would be to the adjoining fence line for the adjoining property at 224 South Town?
That's to the south.
That's correct.
So we had a 10.2 foot setback from the house to that common property line.
Now the question, are you aware that there's a fence line and an easement along that property?
So there is a 5-foot access easement that is on the property in question. And the access easement is, I'll defer to council on this, but I believe that the access easement is written in a way that improvements on this lot can't inhibit the access onto lot 31. We're proposing a driveway and the pavements are gonna connect to the existing pavers. So our driveway does not prevent access of the neighborly property to access their site.
Can you show on the diagram where the fence is? For that easement?
Sure, so I have the existing conditions plan in the top corner. And here's the 5-foot access easement. So it's removed on my plot plan because it's proposed to be removed.
So,
But it's
what's
about,
supposed to be removed? The easement?
no, the fence that exists in the easement.
How can that be removed?
Because the
Have you
easement,
discussed that with the property owner? You're just gonna remove the fence as part of your design and not put it into your plan and discuss that?
the fence is on my client's property in question.
It's part of the easement that was.
The fence isn't part of the, it's an
Let
access.
me answer the one question that is.
Sure, I'm just trying to understand. I'm sorry, counsel, I'm just trying to understand. There's an existing.
I
fence with an
understand what
existing
you're doing.
easement.
All I'm asking is that when you ask a question, give them a chance to answer,
I'm happy
and then
to do
ask
so.
your next question.
Happy to
That's
do
all.
so. Go ahead.
So the fence isn't part of the easement, it's an access easement. So the fence was put there and the property has been vacant for a number of years. So there was no objection to the fence. Now that improvements are being proposed and the fence inhibits our access into the property, it's being proposed to be removed.
Okay, so, and maybe you don't know the answer to this, I can understand. I have a question to your counsel. Are you saying today for the record that the fence that's installed is illegal?
It's not an illegal fence. The fence simply exists on our property and is proposed to be removed.
Exists on your property, but is part of the adjoining property owner's easement, correct?
I would not say that the fence is tied to the easement. The fence exists within the easement, but the easement does not protect the right for the fence to exist in that spot.
Right, so that's one thing that I think we need clarity on, right, is what the rights are of the adjoining property owner vis-a-vis the easement to determine whether or not you have the right to actually remove it or not. Is that a fair question?
I defer to council on.
Okay, that's fair, and we can have that answered. So in the event that the fence is removed as you propose, or whether it is stays or moves or not, are you proposing that the driveway would run right along the current fence line that exists there?
You want me to answer that? I just wanted to let you know that we can, the property owner to the north is willing to sit down and discuss these issues with you, to come to an agreement. If you'd like to sit down after time is over.
Wait, excuse me. Just for the clearance, because we are supposed to make, finally this board will make a decision that is fair and legal for everybody. So could we just make this not as we talk about it afterwards, just let's finish this and make it clear inside the room what you're actually doing. So I'm honestly, I have to say, I'm not so really clear about the history of this fence myself. Local property, I saw a fence, but we probably, like with the help of the council, may more clear understand if what is the current easement, how is the fence linked to that easement, and what will the impact of the neighboring property owner of removing the fence, and what is a possible impact? Will that easement continue to exist, or are you you're requesting a waiver of the easement? I understand right now, and what will be the impact for the neighboring property owner?
Council, you had mentioned that you said that the property owner to the north is willing to talk to you. That may be true, but this is really not relevant because we're dealing with the property owner to the south.
Oh, no, I meant my client would be willing to talk to him. Meaning that the owner of lots 29 and 30.
Well, yeah, I think that the chair has adequately and more than adequately expressed what rights. Your engineer has indicated that fence is not part of any requirement of the easement. This gentleman is saying, how do we know that? I'm assuming that you have some proof with regard to the easement, and if you haven't submitted that, it might be helpful to provide that information.
We did submit the easement to the board along with the deed.
Right, well, now it's become a question.
Yeah.
So you might want to highlight that in terms of where that easement is and what it may say in relation to the fence. I don't know. I mean, I'm suspecting it's nothing, but we don't know that until we actually see what the easement says. And then the secondary question is whether or not the secondary question is whether or not there is going to be an impact on that access easement affecting the southerly property owner. So that may be the secondary question that needs to be answered.
Yes. If the board wouldn't mind, we could have a recess so I can pull out the deed in question. Sure. And
yeah, I suspect you don't have it just like
it's not just like that.
Council, I just have two more quick questions to this.
If you want to continue on and
it's unrelated to
that's fine.
This issue.
Yeah, keep on going.
Thank you. Could you mentioned that the current dwelling has 3 apartments in it, correct?
3 units, yes.
You know how many bedrooms are in total in that house?
I don't, but ownership could provide testimony to that later in the presentation.
Okay, and 2 units that you're proposing have how many bedrooms?
Each unit has 3 bedrooms, and our architect planner can provide testimony to that effect also.
Is someone, I guess you both, but you don't know how many bedrooms are in the current?
I don't have how many units or how many bedrooms are available in each unit, but we do have that information available.
I thought you did a sewer flow study that didn't tell you, does that just tell you by bathrooms or by bedrooms when you did a sewer flow study?
So what I did was estimate the sewer flow from the proposed unit into the new system. So the way that calculation is done is that it assumes that a duplex with 3 bedrooms provides 300 gallons per day. 2 units provide 600 gallons per day. So I estimated this flow. I could estimate this flow as well, but it's an existing service into the system. It's not a new connection that would be subject to review and approval by the Borough Sewer Water Authority.
True, I just think it would be informative for the board to understand the complete impact of the overall site development of existing conditions versus those proposed with respect to that infrastructure. So
That may be your position, but why don't you continue on with questions rather than commentary?
that's fair, happy to do so. Last item I wanted to ask you about, is you mentioned the apron. Is that used for parking currently?
The apron in the right of way?
Mhm.
No, I don't, not to my knowledge. If it is, it shouldn't be. Parking should be contained fully within the site limits. And I think there was a question before also, one of the reasons that we can't use this drive aisle for additional parking is because both spots rely on its common access. And since these units would be under separate ownership, one unit can't block the other unit in. So that's why we have the 2 spots designated in the back of the site for both to access.
Going back to my original comment about, and just calling upon your experience in this as well, hopefully the response is a little bit more clear or defined. In a normal situation, when you're constructing a residential home, is a dry well usually something that's designed as a part of that?
Yes,
It is today's world.
yes,
And why is a dry well being proposed here?
it is
Why is it being proposed here?
at the recommendation of the board engineer.
And do you know why? You may not be able to speak for the board engineer, but is it because of concerns about the runoff from the additional development and the impervious coverage?
When you compare pre-existing stormwater runoff to post-development stormwater runoff, it's a function of surface cover, so pervious versus impervious. So yes, there will be an increase of runoff because we're proposing more impervious surface than there was previously. A way that we reduce that impact to surrounding areas is by proposing BMP, stormwater infrastructure, and grading the site accordingly. So we designed the dry well based on RSIS standards, which we did soil testing for. We found that it was sufficiently infiltrating into the ground. We did a percolation test to confirm that. And we also have no objection to providing the additional stormwater infrastructure to address any concerns from the rear property owner.
Okay, and you did do a perk test, you said?
Yes, we
And
did
that's
too.
been submitted to the board?
It's on the plan right here.
Okay, wonderful. Last question for you. With respect to you have the 2 angled parking spaces in the rear, correct?
That's correct.
So just to recap a couple of the highlights of this, I just want to make sure I'm accurate. So I'm asking the question if I'm being accurate. We have bollards that are being installed in the back to protect the building, correct?
Yes,
There are 3 spaces being put in along the northernmost side of the property that need to access and egress through the 7.5-foot driveway, correct?
that's correct.
And then you have 2 additional spaces that you're proposing on the southerly side along 10-foot, as you indicated, a more standard sized driveway, correct?
That's correct.
And you mentioned RSIS is my last question. What's the RSIS standard for a 3-bedroom apartment with respect to parking?
I believe it's 2 spaces and I think it's 2.2 off the top of my head.
So according to RSIS standards, there should be a minimum of 4.5 to 5, probably 5 spaces for this dwelling, and you're proposing 2. Is that correct?
That's correct. We requested relief from RSIS standards
Okay.
as part of this application.
That's all the questions that I have. Thank you very much.
Thank you.
Thank you.
Maybe, just to respond, maybe the thing to do is to go through the questions of the public, of your witness, and then we'll take a short break so you can end up getting what you need to get.
That's fine with me.
Okay?
Thank you.
Sir, if you come up, again, we need to get you on the mic. If you'd be kind enough to state your name, spell your last name and your address.
Don Stern, STERN, 317 Summit Place.
Maureen, did you get that?
Yes.
Okay.
And I wanted to ask you if you.
If you don't mind, could you speak up, because we need to get you
Sure.
through your mask.
Is
I don't
this
want you to
better?
take your mask off. That's better.
Okay. Have you considered the possibility of runoff from the roof going into the Highland Park sewer system? As opposed to just onto the impervious surface?
When you say sewer system, you mean storm sewer, not the,
Storm sewer.
so I don't believe that there's an inlet in front of our site to tie into. The most desirable situation when grading a property is to direct everything to the street. That is just a principle that we try to abide by when we're grading a site. Unfortunately, we have to build with the land and not on it. We can't force water to go where it isn't already going. So as much as we can adjust the grading to direct everything to South Fourth Avenue, which would eventually drain into the storm sewer system, a portion of it has to go to the backyard because it was going back there already. The alternative would be building the site up, building a retaining wall around the perimeter of the site and forcing everything to go to the front, which isn't, it's not good design practice to build a 3 or 4 foot wall on your side and rear property line. That's not general. We try to design efficiently to fit the land.
Can the driveway be graded in such a way that it does drain into South Fourth and into the storm sewage system? Because you were saying some of it would go that way and some of it would go toward the back. And is there a way of grading the driveway such as that more of it would go toward Fourth?
I think that we can propose, I think we can propose curbing around the rear perimeter of our parking area so that everything, as much as feasible, is draining towards the street. I think we can accommodate that in our design.
Okay, that sounds good.
But then you have to, don't you have to then change the grading? The mere fact that you have curbing is going to potentially stop it, but to get it to go from the back to the front, the curbing is not going to do that. You have to do some regrading to be able to.
We would. So we'd have to, the curb would function as a gutter where stormwater would hit the pavement, it would flow over land to hit the curb, and then the curb would direct the stormwater as a gutter to where we intended to. So yes, it would have to be a combination of curb to capture the water so it doesn't run off of the pavement onto the grass, and grading to direct it to where we need it to.
So there would be some, how much of a grade differential are you talking about? A couple of inches, couple of feet?
So when you're designing a gutter, you set at the bottom of curb grade here, and 50 feet down, you set a bottom of curb grade. You generally want to have at least 0.5%, which would be 0.5 feet, 6 inches over a 100-foot difference.
And that's what you're talking about here?
Yes.
Can you, just to follow up on that, on your plan for lot 29, you have a yard drain. Where does the drain to?
That's an existing yard drain. I don't know where it goes to.
That would be helpful to know. I'm just saying, it would be very helpful to know where this drains to. There's one more question from the public.
Very short. Carl Yanni, 334 Summit Place. Just a quick question following up on the percolation test. Can you explain? I think I understand how the well works, but I'm not convinced. If you could answer how the drainage, if it comes off of the roof, where that goes in the case of a storm. And then also, if you could explain about the percolation test and how it works, because I just know from my experience, our backyard is a big hunk of rock. It's not, it's not very pervious. Thank you, sir. That wasn't worded very well, but
It's not very, can I repeat that phrase for
Please.
myself? Not very, your yard's not very murky. I just like the phrase.
just, yeah, grading toward our backyard is
So-
the word. Thank you.
Completely understood. So the way our subsurface infiltration basin works is that your different roof lines are going to direct runoff, stormwater runoff into the gutters. The gutters are going to transport that water to a vertical roof leader. That vertical roof leader is gonna run down the house and then it's gonna go underground. And then once it goes underground, it's gonna be conveyed with 6-inch pipe at a minimum 0.5% slope into this stormwater trench. And what this stormwater trench is, it's in this case, it's a 3-foot wide by 2 feet tall. So for reference, this is 3 feet by 2 feet. And it's gonna have a 12-inch pipe right in the middle of it. And it's gonna be 12 feet long. So the stormwater that's collected from the roof, from the gutters, gets transported down into this infiltration basin. And this basin is going to store the water in the pipe, and it's going to flow into the bed of clean stone through the perforations in the pipe and infiltrate into the ground. The soil testing we did was in the location of our proposed system. And we had infiltration numbers of 2.4 inches per hour and 4.8 inches per hour. And I believe that would be classified as either K2 or K3 soil. So when you're doing your infiltration tests, you generally take that number and you divide it by half. And as long as that design rate compared to the tested rate is greater than 1 inch per hour, the soils are considered to be suitable for infiltration.
So we are talking, just for us to understand, so we're talking about a regular storm event, and have you made any calculations, because storms are growing, like about a really heavy storm, like a 100-year or 500-year storm?
So the state has very specific standards for stormwater development that's considered a major stormwater development. And what a major stormwater development is a development that proposes 1/4 acre of new impervious area or 1 acre total of disturbance. The lot that we have in question is 4,600 square feet, which is less than 1/4 acre. So statutorily, we're not considered a major stormwater development, and we're not held to those state standards. When you're talking about specific storm events, the major stormwater development would say that you need to meet the quantity reduction criteria for the 2, 10, and 100-year storm. In this case, we're not held to that standard because we're not a major stormwater development. In this case, what we use is the RSIS standard for proposing 1 linear foot of this trench for every 100 square feet of roof area.
So you're telling, just for me to understand, so you're telling us that you're not looking into any major storms because you're not required to, because this is just a small property, right?
Because we're not a major stormwater development.
You
That's
might,
correct.
the thing is that in this situation with the neighborhood situation, it will be majorly impactful for the neighboring property, right? So that's kind of what we are, as a board, as a zoning board, are concerned about. What's the impact of the neighbors of this development? And therefore it's a concern. So it would be helpful to understand what is the, what will be the impact on the neighboring property for a major storm. Even if you're not required to standardize, I'm not sure if I'm doing something wrong, but for the operation.
You know, there's some issues here that you're raising. If they are not required under the statute, under the state statute, to meet a major storm standard, but they are meeting the RSIS standard, there may be a valid position that they will take, and I'll defer. I'm not going to make the case on behalf of the applicant, but I just suggest that there are standards that have to be met, and if they don't meet the standards, they're gonna have to either seek a variance from that or a waiver from that. Here, they seem to be telling you
Mhm.
that in fact, and we'll hear from Bruce as to whether or not what this gentleman is saying as an engineer
Okay.
is in fact accurate, and then we'll get a better idea as to
All right.
where you can go with the information that you're looking for. All right?
One last
Well,
question.
hold on, there may be other persons that have questions. And maybe not.
So go, please, sir.
No, well, yeah, well, take the other mic, let the engineer have that mic.
Engineers, Mike. Just a quick question. You mentioned about the RSIS standards. The RSIS standards that you're indicating you would follow for storm drainage. Just curiously, is that the same RSIS standards that you've determined you don't need to follow with respect to parking?
So RSIS, the residential site improvement standards, is sites criteria for both parking and for storm infrastructure.
So you intend to follow it for storm infrastructure, but don't intend to follow it for the parking?
Our planner is going to provide, the necessary relief to show why we're not substantially detrimenting anything.
I didn't ask that question. I'm just saying, are you following? So you're following.
He's answered that question. He's answered that question. They are not.
Counsel, can I interrupt you a second?
No, you
please,
can't.
sir?
No, you can't.
I can't?
He's answered the question. You asked the question as to whether or not they are meeting the standard for storm.
I didn't hear a yes or no.
And, well, I thought I heard him say.
I didn't hear that. Maybe you could repeat it and then I'll stand corrected.
Okay.
The
Repeat your
RSIS standards, are you meeting it for drainage, but not meeting it for parking is my question. It's a yes or a no.
Yes.
That's the answer.
Now I got the answer. Thank you very much.
When you put in, I'm sorry, I don't have all the plans in front of me and it's a little bit far away over there. I don't know if you're gonna come back for another date, if it's possible to have a second set for this side of the room. Here you go. Thanks. I just wanted to ask if there was consideration of consolidating and just using one drive.
So we did receive that recommendation. And the reason that we didn't design this with one driveway is that if we were, we would end up needing a cross-access easement between the two properties. And generally, when you're subdividing land or proposing development of any nature, you want to design it in a way so that you don't need to rely on someone else's property to access your own property. In the future, 20, 30 years from now, that cross-access easement is going to exist, whether our client owns the property or not. So generally, we try to avoid designing properties that need to rely on easements in order to function. The same way that you could put a sewer easement through your property, and now you can never touch that portion of your property. You try to keep those things in the right of way as much as practical. So that was the reason that we thought that the common driveway that needed to rely on a cross-access easement wasn't desirable in the situation.
So you did think about it.
We did.
So how much impervious structure, how much additional pervious would be there if you only had one driveway, say, going down the middle and pulled up those other driveways?
So it'd be a trade-off, and I don't have the number exactly in front of me.
Notwithstanding what he was trying to say, why don't you continue with your answer as an engineer?
You would be decreasing the driveway in one of the locations, but you'd be increasing it in the back of the site. So with regards to the break line of the property, I think there would be more impervious area in the rear of the site as opposed to it being more balanced towards the front and rear of the site. So I think you'd be increasing impervious area in the backyard, creating more parking area where there currently isn't, even if you're eliminating one of these driveways at the front half of the property. I don't have the exact number, but I think it would be comparable in impervious coverage.
And how would the alternative impervious coverage in the rear affect drainage and drainage, not drainage calculations, but drainage infrastructure, if at all?
We didn't design that, and in order for me to adequately, I don't know how to grade the site that I haven't designed yet.
Okay,
So does your proposed application require an additional curb cut for the new driveway?
It does. It needs a new curb cut on the southerly property side.
So that will also be eating up an additional parking space that's off street from the block.
I believe we're gonna be able to get probably one space in between the driveways. And there's probably one space being eliminated as a result of the new driveway.
Just to be fair, I'll just say, I went through 3 different times and there was, I was surprised because I thought that parking would be a premium there. And there were spots on the street, each of the 3 times I went there. So I'll just share that in general.
Sure.
But that's not a parking study, of course. It's just a lay observation. Okay, I'm sorry if anyone else. Maybe you're the wrong one to ask. So this is a 100% affordable project?
Not the right one to ask.
Yes, it is.
What's the period of deed restriction?
it's my understanding, and maybe this will be clarified, it is not a 100% affordable project under the COA regulations. It's under different regulations. Am I correct about that? Or is it, I want to get a clarification on that, because I did talk to our planner, and I want to get your take on that.
It's under the jurisdiction of the county program using some federal funds. So the proposed dwelling is not subject to the uniform housing affordability controls.
So
It's one
therefore,
of the exempt programs that are exempt from that. So they have their own criteria for the new.
so
structure.
therefore, in effect, what that really means is that the borough is not in a position to be able to take credit for these additional affordable units.
Don't know the answer to that question.
I'm reasonably certain that I am.
What is the period of affordability?
It depends upon the circumstance. It's
A
now-
30-year restriction.
it's now
30-year
up- It's now up to 40 years for,
No, I'm asking whether their actual,
I'm sorry.
they're doing a 30-year.
30 years because they're using national trust funds from the federal government. And their requirement is 30 years.
Right, so to the extent we might give you, let's just say some kind of break, because it's an all affordable project, if it is an all affordable project. That ends in 30 years, right? And we're still left with sort of a messy construction that maybe we're giving you because we're sympathetic to affordable applications. What happens after 30 years? It's just going to be a regular apartment building.
It could be who knows? The restrictions could be renewed. It could fall, if they were renewed, it would fall under the UHAC regulations and be regulated for there. And then you do a new deed restriction for another period.
But that's not guaranteed and that's open in the future.
It's not guaranteed, no.
And under this, what Richard was speaking with you about, whatever the alternative to COA that you're working with the feds on, does it allow a municipality to the same rights that municipalities have under the COA UHAC procedures to essentially?
The answer, in my opinion, is no. In other words, I don't think, based upon what I just heard from council, I don't think that these units will qualify for affordable credits on behalf of the borough with regard to the COA. Well, there's not, I use the term COA, there's no COA anymore under the affordable housing regulations. That's how, have I researched that? No, but I think that they have specific regulations that are very strict. And if these, these are for veterans, which is obviously a very good thing. But it turns out that, and council's right, it is not unusual, I strike that, it is not, it is a situation where municipalities will end up seeking to get renewals of deed restrictions after they're terminated. Could that happen here? It could. Is it guaranteed? No. But is it likely that the borough is going to take advantage of these 5 units as a credit to their affordable housing obligation? It doesn't sound to me as though that's going to be the case.
And Counselor, I want to correct my answer. Yes. Yeah, yes, the borough would receive credits for these new units because they're administered by DCA. So,
All right, well, if you could just verify that, that's kind of important, I think.
yes.
All right, thank you. When you said that there are different regulations under your program versus the, and again, I hate to use the term COA, but you know what I'm talking about, under the affordable housing regulations that are now in place or soon to be in place, it would be helpful to know and to try to verify that the borough would be in a position to take credit for affordable housing under its affordable housing obligation, as opposed to a situation where they could not.
Right, and I can look for the citation
That would be great.
to where that would show that the credits are available.
Thank you very much.
Could I ask one other question? Does the proposed construction meet the adaptability requirements for affordable housing?
I'm gonna defer to architect on that.
Yeah, I think that may be something that maybe he's going to be able to answer that, and maybe not today.
Well, tell me, so are they 2 townhouses or is it a
No.
first floor and a second floor?
First floor and second floor.
So how would somebody in a wheelchair be able to occupy the second floor?
I'm gonna defer to the architect on the
Okay,
ADA accessibility.
okay.
Any other
Any
questions?
other questions from the public or the board? Thank you, sir.
We had asked before if we could have
Sure.
a brief recess.
It's up to the board.
Yes. Like 5 minutes, is that good enough? 10?
10 minutes will be.
10 minutes, 10 minutes, okay, we re-adjourn at 9 o'clock.
Thank you. All right. Welcome back, everybody. So actually, speaking of my colleagues on the board, it's already 9 o'clock, and so we would like to continue until 10 and see if we can have enough clearance for all the open questions that we have right now. And we would like to continue with the experts from the board to follow with that witness, and then come probably when they are satisfied with the answers, then have the next witness speak.
You just have to make it.
Mr. Chairperson, just to recap, we're asking questions of the engineer. Yeah.
Sure. And if you don't mind taking the mic. Thank you.
Without audio, first? It was audio. Did you get the audio before?
Do not in it now.
Okay, I'm gonna ask questions for the applicant's engineer. So during your testimony, you indicated that you'll be willing to shift as a condition of approval the parking lot on lot number 29, I believe it is. 0.6 feet to get a minimum 3 foot buffer.
Yes, that's correct.
And you're willing to put in evergreen landscaping. I heard 1.5 foot on center.
Yes, that's correct.
I don't believe you need 1.5 foot on center. Typically 3 to 5 feet works fine. Evergreen is the more important condition or consideration in here.
Agree to work with you on the final landscaping plan.
And along with consultation with the Shade Tree Advisory Committee, I would recommend. I heard testimony about a fence. Can you just reiterate or clarify for my memory where that proposed fence would be located?
We don't have a fence proposed right now. When we were answering questions of the owner of lot 54 regarding buffering and landscaping, we advised that if it was desirable, we could put a 6-foot fence up along the rear property line, which would be on the west. I'm not sure if that's a desirable situation or whether the landscaping is sufficient. And we're happy to work with the owner either way.
I suppose my reaction to that would be ultimately should go up to the board to decide that, but I think on behalf of the board, I would welcome the neighbors' feedback on that. My question regarding the fence and the landscaping is, do we have any mechanisms to protect them from the motor vehicles? My memo had recommended wheel stops.
We have no objection to wheel stops being put in. Essentially, we don't want the vehicles overhanging beyond the edge of the parking area. So the wheel stops would have the vehicle stop from overhanging beyond the parking area. As we were in our recess, I think it's also very possible to curve the parking area in the rear of the site and to contain the runoff from the blacktop to go completely onto South Fourth Avenue. So I think that there is a way to adjust the grading to prevent that new impervious surface from going to the rear of the site to the front of the site. From my initial evaluation, I think I can grade the site. If necessary, we can put in, inlets with pop-up emitters to pipe it there if necessary.
Was there any consideration for this? I don't think this is my memo, but perhaps converting some of the parking spaces, if not all of them, to gravel and leave the paved area for the drive aisles?
With respect to stormwater runoff?
Yes.
So when we talk about stormwater runoff, you have impervious surfaces that typically have a curve number of 98. And the very simple way of explaining curve numbers is that the higher the curve number, the more runoff there is. So a curve number of 98 means that this isn't exact, but 98% of the water that hits that surface is going to flow downstream. So pavement buildings have a 98 curve number. Gravel would have an 85 curve number, and then the grass area may have a 50 or 60 curve number. So as far as reducing stormwater runoff, yes, slightly. The DEP would consider gravel a motor vehicle impervious surface. The DEP would treat it similarly to asphalt. From a maintenance standpoint, it's not really desirable on a lot of this size to have gravel, just because you're going to have to maintain it. It's going to be subject to, falling out. It's not as stable of a surface as pavement is. And I think with the curve around that pavement area and really containing that runoff from the driveway and getting into the street, I think that alleviates some of the concerns with respect to stormwater runoff.
I'm sorry to interrupt. Can you do me a favor? Could you move closer to him so we get you on camera? Because you're too far away. The camera only gets him and doesn't get you. Like, you have these speech can do that.
Sure.
We'd love to have you on camera.
Love to be on camera.
So I guess the answer is no. No gravel.
We would request that all of the parking area remains asphalt.
The two it's labeled TP-1, TP-2, they're seepage pits. They're proposed on lot 30. Is that correct?
So TP1 and TP2 are test pits.
I'm sorry.
So those are the physical locations that our geotechnical engineer performed a soil analysis on our site.
Thank you. Can you clarify where the seepage pits are going in?
So we're proposing a subsurface infiltration basin in the location that test pit 1 and test pit 2 are performed. And there's a rectangle surrounding that test pit. That's the the footprint of that subsurface infiltration basin.
So that is meant to receive the roof leaders of the proposed duplex?
Yes.
And what about any infiltration measures for the existing three-family? Is any proposed?
Where there's none existing to my knowledge and none is proposed. Sorry.
I heard, actually appreciate the board member Rothberg bringing up asking the question about an alternative driveway arrangement. My memorandum from June 17, 2025, at least for purposes of record, indicated that we during, I guess we can call technical assistance design review, offered 3 different options, with the centralized driveway being just one of them. So is it from your experience that a shared driveway is not typical of a single or two-family development?
I would agree. It's not typical. It's not necessarily uncommon. They're cross-access easements on multiple different properties, but as a designer, we try to lay out sites to limit the need of one site accessing another, especially since these aren't 2 single-family dwellings with 2 units. You know, there's 3 units in the existing building and a duplex in the proposed building. So you don't want to concentrate that traffic into one driveway. It'd be better suited over 2 different driveways. Not that it can't be done, it's just general design criteria. That's how we try to accommodate the site.
So you're telling us that the board planner suggested something that would significantly reduce impervious surface, which is say, but it's like you didn't consider this because it is not done, or maybe unpleasant for the future if you want to sell it off or something, because this would be a difference. I'm asking because a number of the questions you're raising are about impervious surfaces. Certainly the neighbors are raising about impervious surfaces, and so is there a chance that you could prove to us that this is not a proper use, and that we should consider this when granting the variances that you're requesting?
Sure. So as far as 3 different locations, so we're gonna be over here. We have the 7.5-foot wide driveway. It's an existing condition and we're not proposing to change it, but as it was noted, it's not the typical width of a driveway, and it wouldn't be my recommendation to direct more traffic into this driveway. As far as putting a driveway in between the buildings, there's a utility pole there. Can a utility pole be moved? Yes, but typically if we can design with the land, not on top of it, and not have to relocate infrastructure to accommodate our design, we try to avoid it. The third design, putting the 10-foot, putting all the traffic through the southerlymost driveway, it's like, as I mentioned, we have 5 units that are accessing these 2 lots. Spreading it out over 2 driveways as opposed to 1 concentrated driveway, I think is a better use of the land. Generally speaking, although it's an undersized lot, 1 lot, 1 driveway, 2 lots, 2 driveways.
Okay, thank you.
Regarding the southerly driveway that's proposed, what is immediately adjacent to the south?
And an existing driveway.
So from the street, what would you see between 2 buildings?
The driveways are going to be adjacent to each other. There's a small strip between the existing apron to the south and our proposed apron to servicing the southerly lot.
So you know what the setback is from the southerly lot line of subject property to the building to the south?
10.2.
Oh, that's on your property, but to the building on the south. Lot number 31.
I don't have that exactly. It looks to be, this is an estimate, but less than 10 feet, maybe similar at 10 feet.
Yeah, it looks like it could be 8 or 9 feet. So what you're proposing is to repave part of the easement. And ultimately, there'll be about 18 feet of pavement between buildings with no grass strip on either.
Great.
I heard a comment about, I appreciate the turnaround space that allows people to turn around on lot number 29 and exit towards south. Why was that arrangement not considered for lot number 30?
We just simply don't have the space to accommodate that. Essentially, we would need. The existing lot is proposed to be 37 feet, whereas proposed, when I say existing lot, I mean lot 29, like, and lot 30 is 31 feet. So that additional 6 feet helps with that driveway movement.
So you can't fit two heading spaces in the rear lot line, just like the other property to the north of 3 spaces? With 31.67 feet, you need 18 feet of pavement, not counting any buffer that you might want to create. I think part of the justification of the concept I was considering 7.4 the memorandum was to create a condition where people can back out, but don't have to back out onto South Ford.
I'm looking at it, I think it's a feasible solution. You know, typically we have a 9-foot wide spot and a 5-foot key slot. So 9, 18, 23, and we have a 31-foot lot. I think it could be accommodated, especially if we created a buffer. You know, we have 23 versus 31, that's 8 feet. You put a 4-foot buffer on either side yard. I once I start sketching it, there may be something unique, but
and just to finish off on the stormwater, you know, sorry, I'm stealing the thunder, Bruce, but if not having any gravel parking spaces, but you are providing at least a 3-foot buffer with evergreen landscaping, could there be consideration for expanding the buffer to 5 feet or more, given that I heard you say that 24-foot drive aisle is typically a commercial driveway width? Sounds like we can get away with 22 feet, maybe 20 feet for residential. I think there's room to increase that buffer further and perhaps consider a rain garden at the head of the parking spaces. Especially if they're put wheel stops in.
When you say the rain garden would be in the rear.
In the rear
So
property between
instead
the head
of
of the
the
spaces.
3-foot, we have to say 5 or 6 foot.
Right.
Okay, got it.
I'm looking for ways to try to mitigate the issues of stormwater management, even though it doesn't qualify for major development. There's a concern raised in the environmental commission's letter, as well as some neighbors who have come to me who know much more about these issues than we do.
so as far as the 24-foot aisle goes, yes, it's a typical 2-way aisle of commercial space.
For commercial.
For commercial.
Right.
And I get that this is residential, but the 24 feet doesn't just serve for 2-way traffic. It serves to allow the vehicles backing out to perform a K-turn without multiple points to their K. So yes, 20 feet is more than sufficient. You're not gonna have 2-way traffic going in at the driveway. You know, if someone's pulling in, whoever's pulling in is gonna have the precedence, and whoever's in the back of the lot is gonna have to wait until they pull out. I think what may end up happening is, can a 22-foot aisle be accommodated? Yes. Bigger vehicles may have to do multiple points in order to get out of that parking lot. And I think as an engineer, I'd rather have the proper width turnaround area behind the 9x18 space, and have the 3-foot buffer, which we're providing. But we're open to recommendations from the board. If that's something important, 5 feet is important, we could find somewhere to make up the 2 feet.
So to be clear, you would prefer head-in parking spaces with turnaround space in the back,
Yes, for this lot.
but not
For lot 30.
the southern.
really enough? Is 3 foot really enough for this arborvitae?
Well, they're typically spaced, 3 feet on center. I said 1.5 feet as a dense grouping, but 3 feet is.
That's between them, but they get wide, right?
Well, the idea is that the arm length of the trees overlap each other to provide that full wall of coverage. Like if you have spacing, then it doesn't provide the intended buffer. But we could space it more or less based on your professional's recommendations.
My opinion is 3 foot spacing is good to create a green wall. The concern is the depth.
And we're proposing 3 feet in that area.
There's a discussion about 5 feet as an alternative, right?
Yes.
Can I ask a question about this driveway? So earlier you said that the residents in the existing buildings don't use the driveway today? Is that right?
On lot 30?
Yeah.
Lot 29.
Not 29, not 29.
Lot
Okay,
29.
we'll get it right.
I would rather have ownership give testimony to the specific use. I don't know if every tenant has a vehicle, but it's my understanding that there's a bus station in the area. I think there's a grocery market in the area. There is more pedestrian traffic. It is a suitable walking area, so I don't know exactly how many tenants have cars, or what friends and families have cars. But it's.
Was there any consideration to reducing the number of parking spaces to create more pervious surface area?
So we're already underparked. RSIS says that we're supposed to provide the 2 about spaces per each unit, and we're proposing 1 per unit. So yes, we could provide less, but then we'd be requesting a greater relief from the parking standard.
Clear on the parking, I think it was as of August or September of 2024, I believe. The minimum parking standards that we're all familiar with became maximum. In the 3-family building, it's not a detached single or 2-family, it's subject to garden apartment parking requirements. I believe it's 5.9 parking spaces required. 2 exist presently, 3 are proposed, 1 for each unit. I say 5.9 because my understanding, and I think I put it in the report, there's a 3-bedroom unit, there's a 2-bedroom unit, there's a 1-bedroom unit. I guess we'll get confirmation on that. What's proposed are 2 3-bedroom apartments. For purposes of RSIS, it's single or really duplex, but really it's 2 single-family dwellings. For purposes of parking, 3 parking spaces. 3 bedrooms require 2 parking spaces each. We're told for. So the maximum that can be required by the board, or the borough for that matter, is going to be 9.9 parking spaces. That's the maximum. It used to be the minimum, but it's up to the board to accept the lower parking standard. So we're already lower. I actually asked for 1 parking space to be put in on lot number 29. But to that point, who will be giving testimony regarding whether these alternative parking standards should be approved?
Our planner is going to provide planning testimony.
I think that's it for engineering. Actually, one more question, sorry. In the lot number 30 proposed duplex, there is a proposed AC unit.
We showed it, and we're not exactly sure what the heating, HVAC for the buildings are going to be, whether it's central air or mini splits, or an alternative form. If there ends up being a second one, we'll show a second one on the plan.
Okay.
I think one of them may end up being located in the attic or the roof area.
Okay. I have no further questions.
How you doing?
Good, Bruce.
I got some questions regarding primarily the stormwater management is my concern. My item number 6 speaks to that. In a general sense, says the applicant should take all measures necessary to prevent stormwater runoff from negatively impacting the adjacent properties. what we've heard so far from the neighbors as well as from yourself is there is a good chance that the increase in runoff could have a negative impact. So a couple of things I'd like to bring up regarding that. I know you did a perk test, but I don't think we have calculations that demonstrate the size of the infiltration basins based on the runoff and the perk rate. Did you submit anything? I don't believe I have it.
So our detail is based on an RSIS detail that doesn't rely on a specific storm event. It's not based on 210, 100-year storm event, based on a function of what area is contributory to whatever basin we're designing. It's an RSIS standard that states that 2 linear feet of recharge trench, which is the detail that's summarized, shall be provided for every 100 square feet of building area. So that the calculation is within the RSIS detail. If there's a different storm event that you'd like the new roof recharge designed to, I'm happy to accommodate. I don't know if there's anything in the borough ordinance that necessarily requires residential improvements to propose a dry well of a certain size. I'm not familiar with any specific plot plan standards. So I think it would just be at the board's jurisdiction about what storm, but I'd be curious if other single family homes in town were held to a specific standard where new houses need to propose a dry wall of a certain size.
Okay, well, so let's start off with the RSIS. You earlier gave testimony that this is not a major development, am I correct?
That's correct.
So under the borough ordinance, if it's not a major development, or under the DEP regs, if it's not a major development, then you go down to the borough ordinance, not to the RSIS, but to the borough ordinance. And the borough, as I recall, adopted the more stringent of the two model ordinances that could be adopted and comply with the DEP. So I'm going to ask you, when we come back with revised plans, to look into the borough ordinance and specifically design these improvements to comply with that. In answer to your question, we always try to get a connection to a storm sewer. And if people do a base, if they can't do that, then we very often will ask for a base, some sort of stormwater management system. And that's on houses, not where the driveway is running into the backyard and has parking in the back. So this is actually more than just a residential dwelling in terms of stormwater management. And then in reviewing the architectural plans, and I realize you're not the architect, but as it relates to the stormwater management, looking at the roof, it would appear that the gutters that will run from along the two sides of the house. And it's very possible that those gutters could be pitched in a manner to duplicate or more closely duplicate the overland flow patterns that exist today, rather than pushing all of that water to the back to a basin, which over time might choke, or under a serious rain event, like some of the storms we've had in Highland Park, and cause flooding, just even with the curbs that overflow and wind up in other people's property. So I'm asking that you take a closer look at what we just talked about and come back to the board with something that addresses this.
Understood.
Does it close your questions? Any other questions from the board members at the moment? So we would be ready to hear the testimony of your next expert, or actually the document that you were looking for.
Yes, I have a copy of the easement that I believe was submitted to the board. With respect to the fence, I'm just going to read directly from the document. The grantee, which is the owner of the property to the south.
That's lot 31.
Lot 31. Grantee at its sole cost and expense shall reinstall a new chain link fence at a height of 4 feet and obtain at their cost and expense such permits as may be necessary to complete such reinstallation. So in my reading of that, the fence is owned by the applicant and not by the neighboring property owner. And that the neighboring property owner was required to reinstall it as part of obtaining this, the easement from the prior owner.
I'm sure you submitted that, but could you do me a favor and resubmit that just?
I will, sir.
If not to the board generally, to me.
Yes.
And I can look at the whole document.
Absolutely.
So that clarifies that for the moment, correct?
Mhm.
So if we don't have any more questions to the engineer, then do we want to invite the
Yeah, then my next witness would be Louis DeLucia, and he's a principal of the applicant. I'll call him up.
What do we have? We lost the other mic. Or maybe we have-
I think it's over in the professionals.
So do you swear or affirm the testimony that you're about to give will be the truth? So help you God.
I do.
Would you be kind enough to state your name, spell your last name, and the location of your office, please?
My name is Louis DeLucia. It's DeLucia. And my office is located at 141 Raritan Avenue, Highland Park.
Thank you.
You can have a seat if you want, or you can stand. It's up to you.
Be careful of the chair.
How are you associated with the applicant, sir?
So I'm the founder and executive director of Garden State Home, also known as GSH Inc. And our doing business as name is Garden State Home.
And can you describe the nature of the Garden State Home business?
Yeah, we're a nonprofit organization registered with the IRS as a 501c3. We're founded in 2007.
And where is your office located?
It's located on the main street in 141 Raritan Avenue above the Muse Salon.
And that's in Highland Park?
That is in Highland Park.
And you, along with the application, you provided a narrative explanation of the affordable housing programs that apply to both the existing dwelling and the proposed dwelling, correct?
Yes.
I'm just going to ask you to summarize some of the features of those programs. Can you describe the affordable housing program that applies to the existing dwelling on lot 29?
Yeah, the existing dwelling is a three-family building with it's affordable housing for income eligible families that are earning 30% of the AMI or less. And we purchased that property and with assistance from the Middlesex County Housing First Capital Fund.
Okay. And how many bedrooms are in each unit of that dwelling?
Yeah, the property has 3 apartments and it consists of a 3-bedroom, a 2-bedroom, and a 1-bedroom apartment.
And do you also provide support services or counseling to the tenants?
We do.
And is that provided on site or at your office?
That's provided off-site at the office.
And is the existing dwelling deed restricted?
It is deed restricted.
Okay, do you know how long it is?
It's 15 years.
Okay, and you know when that would expire?
Probably in about 12 to 13 years, I would think.
Okay. And do you know if any of the tenants in that dwelling have vehicles?
My understanding is that none of the tenants have a vehicle, but we just moved in a new single mom with her children in. I'm pretty certain that she does not have a vehicle.
And can you describe the affordable housing program that will apply to the new dwelling?
Yeah, we plan to construct a 2-family home consisting of 2 3-bedroom apartments for veterans who are income eligible, also 30% of the area median income. Okay. And we would utilize the National Housing Trust Fund from DCA to purchase that property in conjunction with the Middlesex County Housing First Capital Fund.
Okay, do you know whether the borough would receive so-called COA credits for the new units?
Yeah, DCA actually took control of that process, and it is my understanding, and I had to speak to Francis behind me, who's an expert in this, that Highland Park would indeed receive credits for the 2 units. And also, it's our understanding that they would receive bonus credits because of the population serving veterans.
Okay. And will the new dwelling also be deed restricted?
It would be, and because of the state funding from DCA, it has a 30-year deed restriction.
Under the new regs, it's my understanding that what used to be 30 is now 40. Do you know if that would apply? And if I think I'm right, but do you know if that applies to this property? If it applies?
In terms of how many years it's deed restricted?
Yeah, as opposed to 40 versus 30.
I believe with this program specifically, it's still 30 years.
Yes, as the National Trust Fund funded projects are still exempt from the UHAC regulations, so they would be exempt from the 4-year requirement. Can you briefly describe how tenants are referred to you and qualified to be located in this property?
So tenants are referred to Garden State Home through the coordinated assessment system, which is operated by Coming Home of Middlesex County. So we will get referrals based on families meeting the eligibility. So being a veteran household and gross income at 30% or less, that referral will come to Garden State Home from Coming Home, and we will meet with the family, face to face. We will do their income verification, also their veteran verification, and then we prepare their documents, their application to DCA for the project-based voucher. That's another great aspect of this program, is that it comes with 2 project-based vouchers. So it's affordable and it's sustainable for the 30-year duration, and most likely would be renewed for another 30-year by DCA. But I don't think the program's been around long enough for us to know what exactly happens at that time, but it's written as a grant loan agreement. So if you don't comply, you owe the money, essentially. So you must comply with the terms of the DCA. They put the deed restriction there, and it's our understanding that that would be extended again.
Okay. And just explain why you wanted to locate this housing in Highland Park.
So I graduated from Rutgers, and the reason I did was because I moved to Highland Park from New Brunswick to get away from the 10 guys I was sharing a house with. And
that's good enough reason.
Yeah, and doing that, I eventually bought a house there in 2012. I had 2 children in Highland Park and raised my family in that house. Garden State Home has expanded our business over the last 18 years. Our main office is in Highland Park. We employ over 20 people, and we also own 2 other properties.
Those are the only questions I have. Thank you, sir.
The only thing I missed, and I apologize, when I wasn't paying attention, I was trying to write other things. You indicated that the existing house has 3 units. I didn't catch the number of bedrooms per unit. You could just redo that for me.
Sure, yes, 3 bedrooms, 2 bedrooms, and 1 bedroom units.
Very logical. Thank you.
Any questions from any board member?
So could you remind, I'm sorry. So the current,
First name, then you.
yeah, the current dwelling there has 3 units on the 13-year program left?
Yeah, it was originally a deed restricted for 15 years. And I'm pretty sure that was executed like 2.5 to 3 years ago. So that would be the balance of the restriction, the deed restriction.
So it's effectively for that 15 years is a commitment to work within the framework of the supportable housing program.
For that particular project, we have the funding that we used assisted in, and that was the program requirements.
And so it's actually financially dependent on that program to make it work.
No, it was part of an acquisition. It was assistance with purchasing the property. So the program works by collecting rents from the clients. The tenants pay rent, or they have vouchers from DCA that assist with the fair market rent. And then it's affordable because the families only pay 30% of their income towards the rent, and the rest is subsidized by the DCA voucher.
So the tenant's rent is subsidized by the program.
In that particular project, we only received the Middlesex County Housing First Capital Fund, which is different than the National Housing Trust Fund. The National Housing Trust Fund is really from the state. DCA administers it, so the nomenclature is a little tricky, but we propose to use DCA, National Housing Trust Fund, and the Housing First Capital Fund for the proposed building, which comes with project-based vouchers. 3 years ago, when we purchased the pre-existing building, the 3-unit building, we only use the county funds, and they do not come with project-based vouchers. So we have to assist the eligible tenants in securing vouchers, which make the project affordable and sustainable.
Okay, so there's the existing dwelling.
Yep.
And its programs, and then there's a new dwelling which could be on a different program.
There's going to be, we propose to build a new 2-family, and it would also use the same funding, the Housing First Capital Fund. And
that's to
addition,
acquire the property and build it.
yeah, to pay for all these professionals, all the construction, all the soft costs, the carrying costs. It's very expensive.
Okay, so there's a different support for building it versus operating it and maintaining it?
Yes, the programs that we mentioned, those are for the acquisition and the soft costs for development of the project. And then the operation and the maintenance of the project is done through just collecting the rent like another landlord for the special population.
And is it, if they offer a renewal, is it mandatory or it's optional?
At 30 years?
At the 15 years and the 30 years?
Yeah, the 30 years, I don't think anyone's really sure because the program hasn't been around that long. Yeah, but I've been told by people who are a little closer to the DCA commissioners that the grant loan agreement will just be renewed for like another 30 years, my understanding.
Okay. And the only people that can rent there are people that qualify under the criteria of the program?
Yeah, so we established the population that we want to serve, which is veteran households and that meet the income eligibility.
So you can rely on the fact that that's the program for the duration of that.
Absolutely,
13 or 30
yeah.
years.
Yes.
Mr. Rothbard?
Do the terms of the program require you to maintain ownership, or are you allowed to transfer ownership to tenants?
I'm not sure if I understand the question. We transfer ownership to the tenants?
You took advantage of either federal or state or county money
Yeah.
to get the start, right?
Yeah.
And so for the existing project, it's a 15-year
Mhm.
commitment, the 30 or 40 for this other building you're gonna build. Is there likelihood that during the terms of the affordable obligations that they could be sold to the tenants for owner occupancy?
I don't think that's a likely outcome. I think that would entail me looking at the mortgage agreement and the grant loan agreement from DCA and then condominiumizing the property and going that route.
For some reason, some of the testimony, I thought that these were going to be sold. And
Oh, no, the intention here is complete, like rental for the 30-year duration. And we anticipate renewing that for another 30 years. And yes.
Yeah, the property is subject to a deed restriction that would prevent it being operated in any way other than pursuant to the program's requirements, right?
So why-
for the 30-year period, right?
Yes.
And so just to apologize for that question, but why do you have, so you're making this 2 different properties? Because they're running under 2 different programs, but you will be the owner for both properties for a long time. That's what you anticipate.
Yeah, Garden State Home will own and operate it. In the past, for liability mitigation, we create like an LLC to hold the entity, and Garden State Home is a sole member of that entity. So that is something that
Just for us to understand, because the testimony, just to put in the relationship to the testimony of the engineer, was saying in case this is 2 different owners. So that's why there is not one driveway, but you are telling us now that it's most likely you are the single owner for a long time. So we would need to think about it when we think about the arguments about the 2 driveways, correct? At
Yes.
least that I'm just
Yeah.
trying to get it, just trying to
Yes.
understand.
It will.
Yeah,
Want to
you-
speak to the?
Yeah,
formality?
you may have 2 separate legal entities be the owners of each property,
Understand
but
that.
you would control
Yeah.
both, correct?
Yeah, so
Okay.
GSH Inc. would be the
Thank you.
sole member of both entities.
And a shared driveway is feasible here. From the standpoint of the structure of the system.
I think the engineer spoke to that. So I'm really,
It's
Yeah.
a business structure, right? that if it's two unrelated owners, it's harder to get coordination and cooperation, but here you control both, you'll hold control of both LLCs. It's a feasible business arrangement.
Just a straight question. I'm getting a little confused in this discussion. Are we messing up are we looking at owner versus resident, really? Because the issue of shared driveways for the people who live there, the fact that you are the owner of both isn't as relevant as the fact that different families are sharing the driveway. So I just want you to clarify that are we talking about the resident issue or are we talking about the ownership as the issue?
Is that question for me or the
Or
board?
anyone who can answer it.
I think the point, we were talking about these alternative configurations, and one of them had a shared driveway. And it's a valid point, if there's two unrelated owners, it would require more coordination and cooperation among them.
Unrelated residents, not owners.
So the question is, if I understand your question correctly, is at the moment we have one driveway for 3 cars and one driveway for 2 cars. And these are used by the tenants.
Right, the tenants are the issue.
Yeah, tenants are the issue. So then what we are discussing is the question, if you have one driveway for 5 cars. So then is that a bit, so then what we have to think about is that a much bigger question, like when you come home or go shopping or go to work, whatever, is that more if you coordinate, if 5 car owners have to coordinate one driveway or 3 have to coordinate one driveway? That's kind of.
But it is the tenants.
It's the tenants, but however, the argument of the engineer was, as far as I understood, to say maybe it's a different owner in future, and that's why we need to clear, like owner of the different properties. So now we understand it's going to be one owner of the properties in the long run. I think that's.
I think to respond as best as I can is that you're correct and so are you, but they're different issues. This is a typical lawyer answer, sort of. The fact of the matter is that from a business viewpoint, you're right, it probably makes it a little easier. From a tenant viewpoint, I suspect you're right, it makes it a little harder.
Yeah.
So that's really, these are 2 different issues that you're both dealing with it from a different point of view. So I want to clarify that that's the reality. You know, your point is well taken from a business viewpoint, but from a tenant viewpoint, it's a different issue altogether. They could care less at that point who owns it 5 years, 10 years, 30 years down the road. The question is, how is it maneuverable for them, as is suggested?
Right, how do they get in and out on a regular basis? And it doesn't matter that you guys own the thing. It matters that they have different cars and go out at different times.
But there's other factors here, right? It could affect impervious coverage, right?
Well, you're right.
Maneuverability of the park.
I'm not disputing that, but I just wanted to clarify that, you know, that I understand what your point is that there was that argument, and that argument may be less effective. The question becomes the livability of the tenants under that one driveway scenario. And yes, you're right. Chris is saying that there is a possibility of reducing the amount of impervious coverage. Their engineer is saying that it's about a wash. Now that has to be looked at a little bit further. And I think that there was a request by Bruce to say maybe you could analyze that for the next meeting. All right?
Yep.
I'm hoping what I'm saying makes things clearer, not muddier.
And hopefully there's not an outstanding question for the witness, because we can take the next question if the board's ready.
Chris?
Good, Chris.
My understanding that the property has merged consists of 1 3-family building, 6 bedrooms, 2 parking spaces by virtue of a 2-car garage. Its parent.
Say that again, Chris.
There's a 2-car garage which provides 2 parking spaces for the existing dwelling.
Okay, yeah.
Building rather. So it's my understanding, it sounds like that's been working for all these years. Has it not?
Yes,
They don't have cars. That's
yeah,
why it's working.
our tenants don't have cars typically.
Your current tenants don't have cars.
Yeah, I believe
No
that's the
cars,
case as
no
well.
problem.
Yeah. And that's historically been the case. for the most part.
And do you anticipate, well, how long has that been the situation? Since you own the property, or is this a recent group of tenants?
What is it, what can you, how?
We operate supportive housing programs across the state. We served over 3,000 clients last year. I can say, as with my personal experience of operating the organization for the last 18 years, that most people earning less than 30% of the area median income do not have the household income to purchase a car, to register a car, to fuel the car up, and to pay for car insurance.
Yeah, I'm not asking why, I'm asking, are there any tenants in the?
Right now, I believe there are no tenants that have a vehicle in the 3-family at all, and that has been the case for a pretty significant amount of time. Yeah.
And are you anticipating that will always be the case?
I don't really know who's going to be moving in there with or without a car, but I know that with your request to remove the garage, we decided to do that to maximize the potential parking on that property to 3 spaces.
Right, part of that was thinking ahead, because obviously we have no control over the expiration of the 15-year lease restriction. Because the concern I have, as I think everyone well knows, is who are the tenants after the expiration of the deed restriction?
I think it's rhetorical, right?
It's rhetorical,
Yes, yeah,
right?
yeah.
But
So
without
so the
any-
point is, there may be something about your applicant's eligibility criteria that make them less likely to own cars, but when the deed restrictions for affordability end, it could be anybody, right? And frankly, you could sell the whole kit and caboodle to somebody next year if you wanted to, right?
Not without penalty, because it is deed restricted for 15
I don't
years,
want
and
money
then
built.
the other property for 30 years. And we've been around for 18 years, and our goal is to house people who need it, who meet that income eligibility.
So my concern, I think what Chris is saying is if we allow something to be built, it's likely to outlast any current deed restrictions, right? And then what happens? Did we allow something because of compassion for affordable disabled veterans community that maybe should not apply to general occupants? I think that's a conundrum here, is granting all these things if it doesn't last forever, right? That's my concern.
Yeah.
I guess I'm trying to find a solution, as most planners try to do, to look both sides of the story. So I guess my question, as a condition of approval, would you be willing to as a condition of approval, extend the deed restriction through the same program? And if that program is not available, would you be willing to deed restrict it through the UHAC regulations for 40 years?
I don't think this board has the authority to impose that condition, because it may be contrary to the existing regulations, and extending deed restrictions under UHAC is the province of the council and not this board.
That's why I asked, are you willing to offer as a condition of approval?
I'm saying that you don't have the ability to impose it as a condition, whether we agree to it or not.
You mean enforce?
Well, you may have some legal basis for that. That's as far as I'll go right now. But the question becomes whether or not if your client is willing to agree to a condition, I think that the board has the right, if the client acknowledges the fact that they are willing to abide by a condition, then that becomes a valid condition of the approval, in my opinion.
Understood, counsel.
I guess the other question is, and I suspect the planner will talk about this. If you end up having a property that ends up having, well, what right now is 5 parking spaces, and 12 years down the road or whatever, it becomes undeed restricted. What is the likelihood of a market renter coming in to say, oh, this is a perfect apartment for me, but there, and I've got my 2 cars and my 3 kids, and is that a likely scenario under these circumstances, or does it become somewhat, given the circumstance, a self-fulfilling restriction whether or not it's deed restriction or otherwise. I don't know the answer to that.
I think both applies. I mean, the devil's advocate is that could happen, but generally speaking, and this is something I've used all the time for planning board applications or redone plans, is that these tend to be self-regulated. Tenants who have cars won't come to a complex that don't have parking spaces. So it is self-regulated to a certain extent.
So then why have the parking spaces at all?
But what happens after 15 and 30 years?
Well,
Well,
That's the
I think
question.
I think it's fair to say that, to say, well, because his experience is that generally there have not been people with cars. He hasn't said under his 18 years of experience, none of his tenants from the 3,000 that he's helped, which is admirable, none of them have had no cars. I think there's a need, I think from a planning viewpoint, and I would question any planner that says no car, no parking car are required as a rational statement. I'd like to meet that planner and have some opportunity to talk to them by way of question. So I think the need for some parking is absolutely appropriate, and I think that Chris's attempt to try to get that and Bruce's attempt to try to get that additional parking is appropriate under the circumstances. Now, the question that is ultimately before the board, among other things, is the request for the deviation from the parking valid, along with the questions that are already being raised, is that, is there sufficient consideration with regard to mitigation of stormwater? Those are two separate questions. There may be others that you're going to agree with, but we haven't gotten there. We probably have another meeting to think about it.
I have one more question. The housing for the veterans for the post-2 family. Do you anticipate any need to provide for accessibility?
I couldn't hear the question.
Do you anticipate the need to provide for accessible housing for the veterans?
I think the design took that into consideration for the first floor being close to the ground. But as the plans that exist now are compliant with the DCA program.
No other questions.
So is there no further questions? Are there any further questions for this witness?
I don't think we opened up to the public yet, did we?
Well, no, we haven't opened it up to the public, and I note, based upon the chair's comments, that it is now 2 minutes to 10. So if there are questions, maybe we can extend it just for questions for this witness by the members of the public. And if there are not, maybe this would be a good time to break.
Is there any?
I'm sorry, I had one other question.
Okay, I'm sorry. You're done.
I've been on this board for a while. I'm trying to remember the conversion of the church on South Third. Is that one of your applications?
No, that's another partner agency, the Reformed Church of Highland Park. And they use similar funding sources, and I believe through that, they also got credits for the town.
Yes, I remember that case too.
Yeah.
So
So I remember in that case, we ended up excusing all the off-street parking, I think, and created a new curb cut in front of the building to allow more parking there. On, was that Magnolia, Montgomery?
Magnolia. Yeah. But it's true, there was that has no, but you remember that very long conversations we had about parking and transportation. And so that project has no, as far as I recall, no parking.
I don't think so.
Yeah.
But I'm sorry, I was only asking because I think that project worked out very well for the community, and I was going to give you an extra bonus because of that, but you're not saying.
So is there any comment?
No, not comment.
Sorry, question, of course,
Yes,
question.
So.
Could you please use the microphone?
Unfortunately, we do need to get you on the mic, otherwise we won't be able to hear you.
We need to record you. Oh.
Hi, am I on? Am I on? It doesn't sound like I'm on, but.
Just do that at the bottom. At the bottom, there's a button, maybe?
Yeah, push up, that little clear button. Here we go.
Green. Okay.
There you go.
So I have questions, and you said you're Lou.
Yes.
We spoke in August.
Oh, could you please repeat your name for?
My name is Lisa Huber.
Okay.
But the questions will not be understandable to the people here tonight without comments. And so I can explain the situation and why I'm asking the questions. So I will ask you, do you want me to wait until the next meeting Because I can
Why
do
don't-
that,
you know,
but
I'm sure,
I brought speaking points. They're very quick.
fair enough. And I'm sure that you're gonna be given the opportunity to do those speaking points. I'm sure that you will be here at the next meeting.
Absolutely.
So why don't we just hold those?
Hold them? Okay.
And if you
Even
don't
better.
mind, and maybe you and I, if you're willing, you will stay for a few minutes afterwards. And we can talk. And we can figure out whether it's appropriate to do this by way of questions of this witness and/or either alone and/or having questions of this witness and then having given you the opportunity, when appropriate, to clarify all of the reasons for those questions. It can be done, but we'll have to talk about it.
Okay, all right, that sounds
But
good.
thank you very much. And hold on to your papers, don't lose those thoughts. No, leave it on, just keep it.
There's one more question from the public?
No.
Oh, there you go.
I just have one quick question. The dwelling units would be specifically for veterans, and the existing dwelling is not, correct, sir?
That's correct.
Could the existing dwelling be utilized for veterans as well?
That wasn't the application and the intention, so I'm not sure of the process to change that with the county funding source. I would have to get back to you on that, but that's not what they've been, or, oh, the answer is no. She's from the county.
So you have no right to be able to put veterans into the existing. Sorry? You cannot put veterans into the existing housing. So if a veteran applies, you have to tell them you can't live there?
Well, hold on. Excuse me, your questions are perfectly valid. Your answers, unfortunately, are not, because we don't know who you are. You're a lovely woman, I'm sure, but that doesn't make you a witness as of this point. So what we can do, can I ask you, these are good questions, can I ask you to hold those questions for the next time? If this young lady is going to testify, that would be the time to maybe ask those questions. Thank you very much for your understanding. No, don't give her that. She's not a witness.
I don't have any more questions.
All right, so on that note,
I think it's,
I will make a motion to adjourn the meeting.
Second.
Well, yeah, not a date problem, I'm sorry.
Want to carry?
Yeah, I'll get to that.
Okay.
You stick to the engineering. I'll get to that.
Well, you did pretty good with that sometimes yourself.
No, I can do it plenty. This matter, what I don't have, what I was gonna say is I didn't bring my phone, so I don't have. Maureen, what's the next meeting date? Is it on the agenda?
Actually, it's on the previous minutes. Do you have the previous minutes?
No, that'll only be this one. In any event, this meeting will be carried without further notice until the meeting of October.
27.
Thank you. October 27th, 2025 at 7:30 at this location. No further notice will be provided. All that really simply means, ladies and gentlemen, is that we will be here in 1 month at 7:30. You will not get any other notice. We would look forward to your presence here as you were then at that time as you were today. Thank you very much.
Oh, we are not done. Sorry, the board is not done. The board is not done. So that.
But you're done. We're done.
Thank you. We as a board still have to approve the minutes of the last meeting. How we do that? Of the last meeting and. Oh yes, yes. No, I have it. Okay. Fine. So we want to find out who was it.
Yeah. No, my announcement is perfectly.
Trying to find the minutes.
I got it. I got it.
We did it up the last week.
I have it over there.
Well, all you know. Okay,
Ladies and gentlemen, we are not done.
We are not done. You have to, like, one of the things of, that we always have to look at the meetings from the last meeting and have to review them and have to approve them. However, the board has significantly changed since the last meeting. So I think it is Ms. Copeland, Mr. Rothberg. Were you there for those? You were, okay. So
I will make a motion to approve the minutes.
I second.
would you do the roll call?
Mr. Becker,
Yes.
Mr. Bezel,
Yes.
Mr. Hooper,
Yes. Yes.
Right.
Ms.
Only-
Corbin,
only those-
Yes.
Right.
Well, actually, I couldn't say.
Mr. Rothberg,
Okay, I did not say.
Yeah, he abstained.
Oh, abstained.
Only those three that were here said yes, and everybody else abstained.
Gotcha.
Okay, fine.
Dana, did you vote yes?
Now we adjourned. Thank you. Have a good night.
Somebody that made a-